I want to put two dates in front of you tonight, just two, and then I want to point at the empty space between them. Date 1, July 16th, 2026. That is the day a defense attorney in Vinton County, Ohio, walked a piece of paper into court and asked the judge to silence her client's side of the story. Her name is Kandra Roberts. Her client is Christina Siders, 67 years old, one of the 4 adults charged in the Ohio House of Horrors case. Date 2, July 23rd, 2026. That is the day the judge said yes. That is the day Common Pleas Judge Lena Featherolf Rogers signed the second gag order in this case, 7 days apart. And in that 7 days, according to the Vinton County Court docket, according to the records that are supposed to tell the public what is happening inside its own courthouse, there was nothing. No hearing on the calendar, no open session, no moment where the public could stand up and hear the reasons out loud, no transcript, no sign that anyone had a conversation on the record before that signature went down. In Ohio, that is not how this is supposed to work. And what happened on July 23rd in a small county courthouse, an hour south of Columbus, is a bigger story than a lot of people have realized yet. Because what got signed that day was not just a piece of paper about one case. It was a small window into how much of an American courtroom is now allowed to happen quietly. Before I tell you what the order does, I have to tell you what the rule is. Because if you do not know the rule, the story sounds normal. And if you know the rule, the story sounds alarming. In Ohio, a judge cannot just sign a gag order like it is a birthday card. There is a process. The process exists because gag orders are serious. They shut people up. And in America, shutting people up in a court case is supposed to be the last thing a judge does, not the first. So here is what the rule says in plain words. Before a judge signs a non-dissemination order, which is the legal name for a gag order, the judge is supposed to hold a hearing. In that hearing, the judge is supposed to look at whether there is really a serious risk that the case will be poisoned if people keep talking. And even if there is a risk, the judge is supposed to ask a second question. Is there a smaller step that would work just as well? Could we just move the trial to a different county? Could we just tell the jury not to read the news? Could we just narrow the order to only certain topics? Could we just seal a few specific documents instead of gagging every lawyer in the room? That is what the rule requires. A hearing, a conversation, alternatives on the table, considered out loud, on the record, where the public can see the reasoning. That is not a legal technicality. That is the whole safety valve. That is the piece that keeps courtrooms in this country from becoming private rooms. Because once a courtroom is private, it stops being a courtroom in any real sense. It becomes something else. And on July 23rd, according to what the docket shows and what 3 separate Ohio news outlets have now reported, that safety valve is where the story gets strange. Let us walk through exactly what this new gag order does, because when you see the list of people it silences, you will understand why the news desks in Ohio notice this one. The order covers 1, the prosecutors on the case, 2, the defense lawyers for all 4 defendants, 3, the entire staff of both sides, meaning paralegals, secretaries, receptionists, interns, everyone, 4, the investigators, both the ones for the state and the ones the defense hires privately, 5, expert witnesses called by either side, meaning the doctors, the psychiatrists, the forensic experts, anyone paid to give an opinion, 6, court officials, meaning clerks, bailiffs, court reporters, and 7, and this is the part that is written broadest, anyone acting as, and I am quoting here, an agent or representative of either side. That is a very wide net. It is not just the lawyers. It is anyone standing in the room with the lawyers, anyone paid by the lawyers, anyone sent by the lawyers, anyone the lawyers even nod at on the way out of the courthouse, arguably. Then the order tells all of those people what they cannot say. And I want you to hear this carefully. They cannot give any opinion on the character of the defendant. They cannot give any opinion on the reputation of the defendant. They cannot give any opinion on the credibility of the defendant. And then, this is the piece that made a lot of people stop and read it twice. They cannot give any opinion on the credibility of the witnesses or the credibility of the alleged victims. That last piece is doing a lot of work, because the alleged victims in this case are 16 children. And what this order says is that the people closest to this case, the prosecutors, the investigators, the child welfare workers acting as agents of the state, cannot go on camera and vouch for what those children have said. They cannot say the children are telling the truth. They cannot say the children are credible. They cannot say the children's account is consistent with what was found in that house. The silence is not just protecting the defendant, the silence is also stretching across the children. That is a choice. It might be a legally defensible choice, but it is a choice, and it deserves to be named as one. Now let me tell you about something in this order that has not gotten enough attention. Something the judge put in on purpose. Something that honestly might turn out to matter more than everything else combined. For the first time in this entire case, in the actual written words of the order, the judge carved out an exception. She said in effect that Ohio's public records law still applies, that the order does not overrule it, that the public's right to request written government documents is not silenced by this order, even though almost everything else about the case is. Now, I know that sounds like paperwork. I know that sounds boring. Stay with me, because it is not boring at all. In Ohio, public records law is the reason the press can walk into a courthouse and ask for a document. It is the reason you and I can find out how our tax money is being spent. It is the reason a journalist can request the affidavit that supported a search warrant, or the log of who signed into the courthouse on a certain day, or the emails a public official wrote about a case, or the incident reports filed by first responders. By naming that law in the order and saying it still applies, the judge left one door open, just one, a small one, but a real one. Everything spoken is silenced, but everything written down as an official record, everything that already exists on paper or in a government email server can still be requested, can still be fought for, can still under Ohio law be pulled into the light. That single carve-out is why the story you are watching right now can even exist. Take it away, and this case goes completely dark. Leave it in, and there is one thin rope of transparency left. The people who write these orders know exactly what they are doing. Judges do not put language in an order by accident. Every word is weighed. Every phrase is fought over. So the fact that this carve-out is there says something. It says the judge understands that a completely dark courtroom in a case with 16 children in it would not survive a challenge for very long. She left herself an exit, and in doing so, she left the public one too. Here is something you may not have noticed. 4 adults were arrested in this case. 4 adults are facing charges, but only 2 of those 4 adults have gagged themselves. Christina Siders, age 67, gagged as of July 23rd. Gary Siders II, the father, the 36-year-old, gagged as of July 14th. Same case, same courthouse, same strategy. Now the other 2. Elizabeth Siders, the mother. Gary Siders, the senior, the grandfather. As of the July 23rd order, neither of them has filed a request for a gag order. Not one. No motion. No paperwork. Nothing on the docket asking the court to shut down public discussion of their side of the case. Think about what that tells you, because these 4 defendants are all in the same case. They are all facing the same court. They are all watching the same news coverage. They are all reading the same headlines about themselves, and half of them have decided that silence is their best move, while the other half have decided that keeping their voice is their best move. In fact, Elizabeth's attorney has been the most publicly vocal of anyone on the defense side of this case. He has pushed back on the Ohio Attorney General's description of what happened in that house. He has been talking to the press. He has been shaping a public story about who his client is and how she got to where she is. He is doing the exact opposite of what the other side of the defense table is doing. That is not a coincidence. That is not 2 defense teams that just happen to have different personalities. That is a defense table splitting into 2 strategies right in front of our eyes. And in a case where multiple defendants are eventually going to have to decide whether they hang together or blame each other, this split is one of the loudest signals we have. When 2 defendants want the room quiet and 2 defendants want the microphone, somebody is planning to point a finger. The only question is when. And the second question is at whom. The last thing standing between this case and total darkness right now is a newspaper. And I do not say that to be dramatic. I say it because it is literally what is happening on the record. The Columbus Dispatch, which is one of the oldest newspapers in Ohio, has filed a complaint with the Ohio Supreme Court over the way the original July 14th gag order came down. And they have also been challenging the way certain search warrants and affidavits in this case were sealed, arguing that the public has a right to see the sworn statements that led investigators into that Hamden house. So on one side of the state capitol, you have Ohio's highest court about to consider whether this case is being handled with enough openness. And on the other side, an hour south, you have a county judge signing more silence into place. That collision is a very big deal. Because if the Ohio Supreme Court agrees with the newspaper, that ruling would not just apply to this case. It would apply to every future gag order in the state. It would set a rule about what a judge has to do before they can shut lawyers up in a criminal case. It would become law, real binding statewide law. So think about the scale of what is really being decided here. It looks small. A local case, a local judge, a small county with fewer people in it than some Columbus neighborhoods. But sitting inside that small case is a question about how much of an American criminal court gets to happen behind a closed door. The Attorney General of Ohio stood in front of a microphone on June 30th and called what happened in that Hamden home pure evil. Those were his exact words, pure evil. Every major news outlet in the country played that clip. But if that same Attorney General or the prosecutors working for him tried to say those words today, right now, on camera, they would be in violation of the July 23rd order. Because pure evil is an opinion on the character of the defendants, and opinions on character are exactly what the order forbids. The state's top law enforcement officer can no longer legally say the sentence that started this case. Sit with that for a minute, just sit with it. So here is where we are, 7 days between a request and a signature, no hearing on the record in between, an order that silences everyone from prosecutors to expert witnesses, a carve-out that keeps written records alive by a thread, a defense table split down the middle, and a newspaper carrying the last legal challenge to the Ohio Supreme Court. That is what July 23rd looks like. That is the state of this case tonight. The grand jury in Vinton County is expected in the coming days or weeks, which means the pressure on all of this is only going up from here, not down. Because once a grand jury returns indictments, everything hardens. The charges become formal, the trial calendar starts moving, and every one of these silence tools starts working harder. There is a version of this story where the silence works, where the case gets tried entirely on paper, and the public never really sees inside, where the four defendants sit at a table in a courtroom for weeks, and nothing about their side of the story ever reaches you. There is another version where the newspaper wins its challenge, and every document that was sealed suddenly is not. Where the affidavits come out, where the reasoning behind the gag orders comes out, where the public gets to see what its own courts have been doing on its behalf. I do not know which version we are getting yet, but I know this. When you cannot hear the people who work inside a case, the only thing you can do is watch what they file, watch what they seal, and count the days between the two. July 16th, July 23rd, 7 days, no hearing. That is not a small detail, that is the whole story. Stay with me on this one. It is going to get louder before it gets quieter.